Well, good morning and welcome to the World Arbitration Update. My name is Ian Laird. I'm a partner here in Washington, D.C. at the law firm of Crowell & Moring. I want to introduce our first panel of day 2 of World Arbitration Update. I'm here with my colleague, Dr. José Antonio Rivas, and his team from X-Strategy LLP, who have masterfully organized this incredible one-week conference. In particular, thanks to Anna and Maria Lucia for all their work. I'm sure you've seen their names on the emails. It's also my pleasure to thank our sponsors. We've put their names up on the screen for you to see. I can't name them all, but they've all been invaluable and incredibly supportive, and our sincere thanks to them. We also have many supporters who've agreed to promote the conference and who have supported our fundamental idea of expanding arbitration beyond the typical centers to recognize, in fact, the real developing diversity of international arbitration practice and practitioners all around the world. And this morning's first panel is certainly a reflection of that, of the growth and development of international arbitration in Africa. And we're very pleased today to welcome this incredible panel. I'm going to pass over briefly to my colleague, Dr. Rivas, to say a few words. But it really has been a pleasure, and I want to thank our moderator, as well as in particular call out Efemina, our presenter today, who was really a driving force behind helping to organize this panel. So thanks so much to both of you. And I'll ask Dr. Rivas to say a few words before we kick off.
Thank you, Ian, and thank you, to all our sponsors. I would simply emphasize that this panel, yes, did have a driving force in Efemina, as well as Uchiora, who is our moderator. Uchiora on Wamamegu, and I would like to emphasize that the panel is the first panel of the second day of World Arbitration Update here in Sub-Saharan Africa. For those of you who are new to World Arbitration Update, as my co-chair has indicated, the WOW is an effort of many, and it's as one of the panelists described it, has a high degree of ambition, in the sense that we are now being connected in 5 continents. And not only that, we're doing this World Arbitration Update both in hybrid panels and fully virtual panels. This is a fully virtual panel, and we're trying to attain two objectives. One is to update on issues of international, commercial, and investment arbitration, and also on issues of public international law. And we are also attempting to decentralize international arbitration, in the sense that that international arbitration not only happens in some of the centers or most important centers of the world, but it also happens in various cities and places in the world, including in Africa, in Latin America, in Asia, also in other non-central places of the world in Europe and of course that is the other objective. With that, I would like to introduce Uche Oda, who is our moderator, and Uche Oda, I had the pleasure of being his colleague for many years at the International Center for Settlement of Investment Disputes. Over a decade, he was a senior counsel at ICSID, and his current practice is now focused on international arbitration, commercial disputes, and advisory services. He is a international attorney at the firm Arendt Fox, and there he advises the state of Kuwait's multi-billion-dollar national focal point for environmental projects. He's a member of the board of the Silicon Valley Arbitration and Mediation Center and of the Lagos Court of Arbitration. He's also on the panel of arbitrators of ICSID and various other arbitration institutions around the world. He has served as presiding sole and co-arbitrator in disputes before ICSID, the International Chamber of Commerce in Paris, the Permanent Court of Arbitration in The Hague, the Court of Arbitration for Sports in Lausanne, the American Arbitration Association, New York, and the Dubai International Arbitration Center. And most importantly, I would say, he's in the advisory board of the World Arbitration Update. With you, I would like to welcome Uche and give him the floor so that he introduces the panel and all the panelists. Welcome, Uche.
Thank you. Thanks, Jose Antonio. And I'd like to say a big thank you to you, Ian, Anna, and huge congratulations on this wonderful project that you've embarked on. It's growing from strength to strength each year, and thanks for involving us. So, to the subject of our panel, Sub-Saharan Africa and the developments there. Why Sub-Saharan Africa? I mean, this is a complex region of about 1.5 billion people, over 1,000 languages, complex legal systems, and so on. Yet, it's one of the poorest regions of the world. The upside to that is that that status of poverty means opportunities. There's a lot of growth potential in the region because the population is mostly young. Now, along with those opportunities come disputes. Increasingly, there are disputes, and increasingly those disputes are being resolved by arbitration. And that brings us to the subject of our panel today, looking at the developments in arbitration, international arbitration in the region. So vast area to cover, but very luckily we have an excellent panel here today to tackle that. I couldn't have asked for a more capable set of hands to embark on this with. We've got Ana Carolina Delagnol, Efemena Obaudu, Abayomio Kubote, Nzeri Kariuku, and Victoria Keegan. Profiles are really vast and extensive, and I would take the whole day if I were to start introducing everyone. So what we've agreed to do is to invite each of our speakers to just say a few words about themselves as a way to get started. And with that, in alphabetical order, I will turn to Ana Carolina to say a few words.
Thank you, Uche. So I'm Ana Carolina Delagnol. I'm a dispute resolution lawyer and an assistant editor for Africa at the Kluwer Arbitration blog. I'm also currently a PhD candidate at the University of Oxford, as well as a tutor in civil dispute resolution. Thank you.
Thank you, Anna. Next, we go to Efemena.
Right, good morning, good afternoon, good evening, wherever you are. My name is Ifemena Louisa Baudu. I am a disputes practitioner as well. I started off my practice in Nigeria, a commercial law firm, where I did mostly commercial disputes. Last year, I decided to run off to Switzerland, Geneva, to pursue an LLM in international dispute settlement. And now I work at Linklaters in London as an international arbitration trainee, pretty much. And that's it. Thank you.
Thanks, Femena. Abayomi?
Thank you, everyone. Good morning. My name is Abayomi Okubote. I'm the managing partner of Pensbury Attorneys and Solicitors. It's a small arbitration law firm in Abuja, Nigeria. I'm also the executive director of the Africa Arbitration Academy.
Thanks, Abayomi. Next, we go to Njeri.
Good afternoon from Nairobi, Kenya, from I practice. I'm a chartered arbitrator and of several years standing now. I've been practicing since 1992, if that's of any interest to anyone. And I mainly operate out of Nairobi, but I'm happy to do training, tutoring, and anything relating to arbitration online and anywhere else that my services may be requested. Thank you.
Thanks, Njeri. And then finally, we have Victoria.
Good afternoon, everybody. My name is Victoria Keegan. I'm a Kenya licensed attorney with over 6 years of experience in dispute resolution. I'm also currently a case counsel at the Nairobi Center for International Arbitration and soon to be licensed as an attorney in New York. I hold a Bachelor of Laws degree and also an LLM in International Arbitration from the University of Miami. I'm happy to be here.
Thank you, Victoria. And with that, we will jump straight into the business for the day. Just a few words on how we've organized ourselves. There will be a presentation by FMNA to start, and then the presentation will be like an overview of the different areas that we will be covering. This will be followed by the subsets of our subtopics from the main topic that we've agreed to cover, and these will be handled by different speakers, with others commenting as they see fit. So I will call on FMNA to get us started.
All right. So thank you, Doctor. It's a pleasure to be here, and I'm just going to briefly run through. I think I have 10 minutes just to give you a high-level overview of what we're going to be discussing today. And we're going to make this very, very, very straight and smooth. And I'm just going to start off by saying, I spent the last year in Geneva doing my master's program, and in between academic work, I found myself discussing so much about the continent and about the region with my colleagues, with members of staff, and with the teaching faculty. It was mostly about the social life in Lagos, trust me, nothing else. But in the middle of all those conversations, I did find time to speak to a few people about arbitration on the continent, and in particular, a partner from a global arbitration practice, one of the leading practices. And the question he asked me was very simple. He said, what's the market like? And he was very practical, what's the market like? Is arbitration a big thing there? People actually do arbitration? Are there clients who can pay, It's very easy to get offended by these questions when you come out from Africa and you've done this in Africa. But I mean, these are valid questions when you're talking about a global perspective to the region. And these are the questions that have informed my presentation. So essentially in my presentation, over the course of the next 10 minutes, so 9 minutes now, I'm basically going to be showing that, there's a market in Africa and there's promise in Africa. And this presentation rests on two propositions. And the first one is that the international arbitration market in Sub-Saharan Africa is one for the present, and with the African Continental Free Trade Agreement, clearly one for the future, and one we should start to look to from now on. And the second proposition is that even without the AFCTA, which is the African Continental Free Trade Agreement, and which is an international law instrument, that the changing international arbitration framework, even within the domestic setup in the region, makes it a prime destination for international arbitration business. And I just like us to keep both propositions in mind while I run through, but I'm going to take the first one first, which is that it's a market for now, and the market for the future, particularly with the African Continental Free Trade Agreement in mind. And this just piggybacks off something, that Dr. Uche mentioned in his presentation. He talked about how, there's opportunity in Africa and there's investment inflow. And with investment, lawyers know now, we typically say disputes are inevitable. I've come up with my own coinage, which is that disputes are characteristic of a business environment. But there's empirical evidence for this as well, in terms of the inflow. I was just looking through the UNCTAD statistics for foreign direct investment inflow. And I noticed how, with COVID, there was a huge drop in investment inflow across the world. But there's a bit of a pickup since, post-COVID era, precisely 2021. The rest of the world actually witnessed a bit of a 50%, 70% increase in FDI inflow post-COVID. But in Sub-Saharan Africa, just to show you how the business is moving, we witnessed a 150% growth in foreign direct investment inflow. And that just shows the investment potential in the region. Now, with this investment potential, it's not hard to see that there will be, more business within the region and then more arbitration. And the good thing is that this has always been the case, and it's not just been business as usual. It's not just been the regular cases. We've also had groundbreaking cases that have been subject to global discussion. On the commercial side of things, we've had the P&ID award. It was about, if I remember correctly, $10 billion against the Federal Republic of Nigeria. It's not the most glamorous story for me, but that is what it is. And on the investment side of things, we had the World Duty-Free Arbitration effectively rendered against the Republic of Kenya. And if you think about this, you can see that, it's not just the peanuts and peas on the continent, it's also the big ticket cases. And if you have any doubts, you can see the flurry of leading arbitration practice on the continent, grappling for, continent-based awards and continent-based practices. And looking forward, it only looks better. And this is where the African Continental Free Trade Agreement comes in. It's an agreement that came into force in January 2021. And it's an agreement that seeks to liberalize trade on the continent primarily. It's just to show its significance. It establishes the largest free trade area by geographic site and population in the entire world. And it's the second largest free trade area in terms of number of member states, coming only after the WTO, which is, of course, indomitable in this case, unbeatable in this case. But the highlight of this instrument is the instrument investment protocol, which is currently being negotiated. While the details are not yet public, it is expected that it would see the introduction of continent-wide standards of protection and market access for any investors who come to the continent. Several instruments already point us in the direction that this protocol is going to go into. For instance, the SADC instrument and the Pan-African Investment Code. However, the most recent one, and which I think is the most groundbreaking one, is the African Arbitration Academy's Model BIT, which is published about 2 months ago and which is likely to be highly influential. Thankfully, we have Dr. Abayomi Okubote, who was a major driver of that project, to discuss that in detail subsequently. The future certainly looks bright. But even if we take aside the AFCTA and we move on without that, it takes us to my second proposition, which is that even the domestic framework of states and the private participation in international arbitration shows that it's still a prime destination for international arbitration business. And the key point here is how the trend shows that states in Sub-Saharan Africa are taking steps to reorganize the international arbitration legal environment to support international arbitration on the continent. And the most recent example is the Sierra Leone Arbitration Act of 2022. It was passed by the legislature in August and assented to by the president in September. The law domesticates the New York Convention and implements the obligations of Sierra Leone under the ICSID Convention. The most significant thing, though, is that it replaces a 62-year-old legislation which has its origin in British colonial rule. But it's not just Sierra Leone, like I said. Months before the Sierra Leone Act was passed, the Nigerian federal legislature thankfully passed an arbitration and conciliation bill, an arbitration and mediation bill rather, in a bid to replace the 1988 legislation. This bill is still awaiting presidential assent, but if you've ever done business in Nigeria, ever done arbitrations in Nigeria, you can tell that the entire community of arbitrators in Nigeria is buzzing with excitement about this bill and its innovations. A couple years before, I think 4 years before, we had two major regional blocks. I call them regional blocks, not just countries, because of the size and the importance. South Africa and the OHADA region, which comprises 17 states in Central and West Africa, also reformed their arbitration laws. South Africa opted for an almost verbatim adoption of the ancestral model law, actually a verbatim adoption with a few qualifiers, while the OHADA region just strengthened what they had. But it really just shows movement in the direction of harmonizing and modernizing international arbitration laws in the region. But it's not just the parliament. We could look at the courts also taking steps in the right direction. I recall in the course of my research, reading decisions from Ghana and Kenya and being particularly impressed with the support given to arbitration by courts, plugging holes in what we consider inadequate legislations, meaning that they might not even need to amend their legislations, and ensuring state compliance with obligations under the New York Convention. The most striking example for me for Ghana was the enforcement of an arbitration agreement that was incorporated by reference. And in what I think was a sleight of hand, the Ghanaian Act, ADR Act, fails to expressly recognize formally an arbitration agreement incorporated by reference. And the Accra High Court, if I remember correctly, actually refused to enforce an arbitration award and stay proceedings just because the arbitration agreement was incorporated by reference. But I saw the Ghanaian Court of Appeal and Supreme Court actually upturning that decision and making sure to say, our laws and form of validity are broad enough and we can incorporate that. It doesn't have to be expressly stated. And finally, I would say my final pointer to just how much arbitration is going on the continent is the rise in ad hoc arbitrations, but most importantly, the activity of arbitral institutions home and abroad to improve arbitration on the continent, to promote it and to teach it. And some of these institutions are, of course, the Nairobi Center for International Arbitration, which is represented by Victoria, who will speak about this, the Lagos Court of Arbitration, which is in my home country, the Lagos Chamber of Commerce International Center for Arbitration, which is also in my home country, the Kigali International Arbitration Center, and of course, the OHADA Common Court of Justice and Arbitration, which has a big reputation on the global scene already. If anybody remembers the GETSMA arbitration, if you don't remember, it's probably a good time to Google it. But it's a very important institution in the sense that it's the one institution that doubles as a supranational Supreme Court for the OHADA region, 17 states, which operate under one Uniform Arbitration Act, and also as an arbitral institution. So it's a supranational Supreme Court and an arbitral institution, meaning that its policy objectives as an arbitral institution are achieved by its harmonization of the law under its practice as a Supreme Court. It's truly thrilling stuff. But also there have been global arbitral institutions like the ICC and the LCIA, which have played key roles in resolving disputes on the continent. Of course, the Chartered Institute of Arbitrators UK is not to be left out, having done tremendous work with educating practitioners on the continent and spreading the arbitration gospel. I would say all in all that the region is on the rise, but it's not just on the rise, it's a region with tons of promise for now and the future, for practitioners, for investors. And this is something to bear in mind. I am very sure that my colleagues would deal with this in a bit more detail, and I implore you to listen to the extremely knowledgeable and distinguished panelists who you've already met and who will speak shortly. Thank you for listening, and I'm happy to connect subsequently after the program.
Thanks a lot, Efemina. That was a real comprehensive overview. We could even stop now, but we will not. So, so what we've done is to kind of devise a way to unbundle everything we've heard from Efemina. And with that, I will call on Anna to start the process of unbundling. Anna is going to speak on the legal environment for international arbitration and its capacity to support the arbitral process in Sub-Saharan Africa. Anna, over to you.
Thank you, José. Good morning, everyone. Hello from Maputo, Mozambique. I would like to thank the World Arbitration Update team for the kind invite to join this session. I'm happy to be part of a panel with such knowledgeable and experienced arbitration practitioners and thinkers. But before starting the presentation, I need to make the necessary caveat on how challenging it is to draw conclusions on developments in Africa. The reasons for that are multifold, but I'll focus on three. First, by referring to Sub-Saharan Africa, we are of course speaking about 48 jurisdictions, which have incredibly diverse legal traditions, common law, civil law, Sharia law, not to mention customary law and legal pluralism. Second, and as a consequence, not only the legal traditions are diverse, but also the needs, priorities, and available resources of African states to advance an apparatus for international arbitration. In this sense, while key arbitration developments in jurisdictions such as Nigeria, South Africa, Kenya, Rwanda, and Mauritius are well reported and inspiring, evidence of other jurisdictions is still lacking. Third, and it is also challenging because I believe that looking at Africa requires the use of analytical lenses, which could focus on a commercial perspective of the developments, or it could be a bit more critical, probably looking closely and doing some justice to common aspects of Africa's history and legacies of colonialism. I'll do my best to weigh these sides, if that is even possible in 7 minutes. But going beyond these caveats and starting the presentation, luckily Africa's arbitration options and caseloads continue to rise. And many of these developments will lead to a progressive relocalization or Africanization, to use Mbengue's and Shahade's words, of international arbitration. Among the developments we are seeing today, we can highlight that most African states can be said to have adopted modern arbitration. At least 10 African jurisdictions have officially adopted the UNCITRAL model law, according to the UNCITRAL, while many more countries have looked to the model law for inspiration for many or some of their national laws provisions. 36 Sub-Saharan African jurisdictions are contracting states to the New York Convention. 42 Sub-Saharan African states have ratified the ICSID Convention, with Angola's deposit for ratification having taken place just 5 days ago. There has been a rise in the number of African arbitral institutions. The 2020 SOAS survey report has identified 91 African arbitral institutions. And perhaps more importantly, there has been a proliferation of Africa-focused arbitration initiatives, events, and publications by and for African practitioners, such as the Africa Arbitration Academy, which fosters specialized, fresh, and critical thinking. When it comes to caseload, the rise in the number of cases involving African parties is small and steady. In 2020, cases involving Sub-Saharan African parties represented 6.8 of the ICC arbitrations, 11.7 of the LCIA cases, and 15% of ICSID cases. In regard to African arbitral institutions, the Arbitration Foundation of Southern Africa, the Kigali and the Nairobi arbitration centers, of which Victoria is a case counsel, have reported rises in their caseload. With this overview, I will now look into some detail at recent developments that could shed more light on the legal environment for international arbitration in Sub-Saharan Africa. But in the interest of timekeeping, I will focus on the role of national courts for determining the legal environment for international arbitration. Abayomi will further expand on developments on national arbitration laws, as the Africa Arbitration Academy and Abayomi himself have participated in the preparation of the new Sierra Leone and Nigeria Arbitration Acts. And it will be great to hear him speak more about the interesting features of these laws. And personally, I'm super interested in hearing more about the optional feature of resorting to an award review tribunal in accordance with the Nigerian Amendment Bill. But turning then to national courts, I'll focus on 3 factors affecting the choice of an African seat. The first is time and costs as interlocking aspects. The second is expertise and pro-arbitration approach of courts. And lastly, publicly available decisions. Looking first at time and costs as 2 interlocking aspects, delays have time and cost consequences to the litigation process. And this is confirmed by empirical evidence from the Africa Arbitration Academy 2022 survey on costs, which has revealed that duration is one of the main factors driving up litigation costs in Africa. Emilia Onyema, in her 2018 study of African courts, made the thoughtful observation that in most African states, there is no cost incentive for litigants to avoid courts. To the contrary, the cost of access to litigation for civil matters is an incentive to use the court system, which may lead to the clogging of the judiciary. A slow judiciary may not only impact the effectiveness, efficiency, and fairness of dispute resolution, therefore potentially discouraging the choice of African seats, but with time, it may also make access to justice via courts prohibitively expensive for most African people. Turning now to courts' expertise and pro-arbitration approach, increasing the capacity of national courts and judicial familiarity with issues concerning international arbitration is also important for providing a stable and predictable environment for arbitration. Interestingly, the Africa Arbitration Academy survey revealed that while 60% of the respondents stated that delay in court proceedings has an impact on litigation costs in their jurisdictions, 38% of the total respondents believe that the lack of subject matter expertise of judges impacts litigation costs as well. Indeed, features that are generally seen as desirable for national courts while supporting international arbitration, for instance, to be well-versed in commerce, be international in outlook, and understand arbitration, are minimal qualification judges need to have to decide on arbitration matters. Looking at the national courts taking a pro-arbitration attitude, empirical evidence from the SOAS survey report indicate that the top 5 African seats are South Africa, Nigeria, Egypt, but outside Sub-Saharan Africa, Rwanda, and Côte d'Ivoire. And this is confirmed by the Africa Arbitration Academy survey, which further indicated Kenya as a favorite seat. When it comes to publicly available decisions, it is still challenging to obtain access to decisions on arbitration-related matters rendered by African courts. Jurisdictions such as South Africa and Kenya have developed websites to bring decisions to public domain, and I believe that many would benefit from having access to the text of decisions, not only arbitration practitioners and of course their clients, but also African judges would be able to follow developments in the region. Needless to say that having access to court decisions would also be very interesting for showing Africa's participation in international arbitration jurisprudence, which could be another pillar of the Africanization of international law. Thank you very much, and I would look forward to expanding on any of these topics with the panel or the audience. Thank you.
Thank you, Anna, and that was a good kickoff because you were just right on time. Now, perhaps Abayomi or any other panelists wants to say a word or two, or does anyone have an observation on what Anna has just said?
Thank you very much, Uche. Perhaps I should step in now, mainly because, and I share Femina's sentiment that Sub-Saharan Africa is a place for the future. Femina has rightly referred to two recent developments in relation to legal framework for arbitration in Africa. Those are the developments in Nigeria and in Sierra Leone. I was privileged to have been part of the drafting committee for both bills. So I'll try to identify some of the essential features of some of these bills. The Nigerian bill, which of course we are waiting for the president to sign into law, that has been passed by both chambers of the National Assembly in Nigeria, the Nigerian Parliament. That bill stipulates several innovative provisions, including the award review tribunal that Anna referred to. And the essence of some of these innovative provisions is to provide solution to some of the inadequacies that we've experienced in the Extant Arbitration and Conciliation Act. And I'll just identify some of these innovative provisions. The first is provision relating to third-party funding, which I was privileged to have drafted. Provisions relating to appointment of emergency arbitrators to grant urgent reliefs. Provisions relating to immunity of arbitrators. Incorporating some of the useful provisions in the 2006 amendment of the Ancestral Model Law, provisions relating to the Award Review Tribunal. And we're hopeful that once the president assents to this bill, it will replace the Extant Act, and of course, begin to position Nigeria as one of the leading seats for commercial arbitration in Nigeria. In relation to Sierra Leone, 2 years, the bill was passed on 2nd August 2022 That was 2 years after Sierra Leone had assented to the New York Convention. And the bill was also signed into the law on 6 September. And this has been, has by far been one of the most significant events in Africa because of some of the provisions in that law. That law seeks to remedy the flaws and inconsistencies in the erstwhile regime, the ordinance that Ifemina referred to. And what we also did was to use that same law to domesticate the New York Convention to give force of law to Sierra Leone's obligations under the convention. Some of the key provisions in that law, of course, we have provisions on third-party funding, which, following the approach adopted by Singapore and Hong Kong, expressly has abolished the thought of maintenance and champerty in relation to funding of arbitration in Sierra Leone. It also includes provisions relating to mandatory disclosure of third-party funding arrangements in arbitration proceedings. We now have, by force of that law, the establishment of the Sierra Leone International Arbitration Center. The center, the responsibility includes facilitating the conduct of international arbitration in accordance with the law. Presently, we do not have any standard, as we have NCIA, KIAC, Corsica, LCA in different countries. In Africa, we do not have a standard arbitration center in Sierra Leone. So we now have the Sierra Leone International Arbitration Center by force of the new law. By that law, the courts may now also issue interim and supplementary orders for the purpose of preserving the right of parties in arbitration, which we did not have in the erstwhile ordinance. And we also have several provisions relating to emergency relief proceedings, the power of court to grant interim measures of protection, confidentiality, which is, of course, the law becomes one of the few laws or statutes that you find around in relation to arbitration that has express provision on confidentiality. And of course, several provisions relating to enforcement and recognition of foreign awards, modeling the provisions of the New York Convention.
Thank you very much. That kind of helps us to unbundle and unpack that. And having done that, it'll be nice to start digging into the specifics now in terms of how things are actually working today. And on this, I'll call on Victoria and Njeri to tell us about the role of ad hoc arbitration and the growth of arbitral institutions in the markets that we're talking about. Njeri, you can unmute now, and Victoria, you can unmute as well.
Thank you, Uche. I'm going to open the floor by just talking a little about ad hoc institutions as follows. I think it's safe to say that ad hoc arbitrations are the precursor in Sub-Saharan Africa of institutional arbitrations. Maybe this is across the world, but I say this despite the lack of empirical data to back up my assertion. This is my belief. I first heard of a construction arbitration in Kenya all the way back in 1985 involving two private parties. And although I have no idea who appointed the tribunal in that reference, I would not be surprised to be told that the Chartered Institute was involved, considering that the Institute had opened its doors in Nairobi in 1984, with those spearheading it being construction professionals. As a default appointing body, Chartered Institute Kenya has over the years maintained statistics on the number of arbitrators appointed in ad hoc references, but this number cannot possibly be reflective of the actual number of references, considering the confidential nature of arbitration and the fact that over the many years of its existence, the Chartered Institute has inveigled itself into many a contract as the default appointing body. This is quite apart from the LSK, the Law Society of Kenya. But as we all know, CIF does not administer. In the last decade, however, the growth in such appointments has been phenomenal. It's apparently over 300 last count. Nigeria is on the same footing as Kenya, according to the SOAS 2020 survey. But of course, the numbers will be much larger considering the demographics. ICAMA, or the International Center for Arbitration and Mediation, Abuja, has been identified in the survey as having administered the majority of ad hoc arbitrations in Nigeria. Other countries in the region where the Chartered Institute has gained a footing besides Kenya and Nigeria are Mauritius, South Africa, Zambia, Zimbabwe, Rwanda, and just lately Uganda. The Institute's popularity in Africa can be attributed to its worldwide recognition of the training modules that it offers, as well as certification, and a firmer footing in the continent through the establishment of semi-autonomous branches, each with its own leadership and structure. Consequently, it has taken up a significant market share in arbitral appointments. In Kenya, owing to the length of time it has been on the domestic stage, it is the most popular arbitral institution, notwithstanding the fact that it is not homegrown, nor does it administer arbitrations, as just mentioned. Needless to say, ad hoc arbitrations on a domestic level have been a diving board for practitioners into the realm of international arbitration. And it may well be said that general interest in Africa in the context of international arbitration may possibly be attributed to the growth, amongst other factors, in the capacity of African practitioners. This has contributed to a positive shift in attitude and the bolstering of pro-arbitration policy and legislation that has the overall effect of creating arbitration-friendly jurisdictions in Africa. This attitude also extends to the judicial approaches in promoting arbitration as an alternative avenue for access to justice. Now, Victoria. Having said all that, it is quite evident that there has been the rise, oh, good gracious, of arbitration hubs within the region. Please elaborate on some of the unique developments of institutional arbitration within the region.
Thank you so much, Njeri, for that question. And I think when it comes to discussions regarding the unique developments of institutional arbitration within the region, particularly the Sub-Saharan region in reference, I would want to embark on this discussion as regards, the recent developments, the arbitral institutions that have been developed. And in that regard, then I will just point out on each particular region. I'll start with South Africa. So South Africa's leading arbitral institution is its 24-year-old Arbitration Foundation of Southern Africa, normally known as AFSA, which has achieved a degree of success and has demonstrated a keen desire to develop further. Also, apart from the fact that it conducts, it administers domestic and international arbitration, also that it had a legal exchange with China. And in August 2015, AFSA launched a new international arbitration center dedicated to the resolution of commercial disputes between Chinese and African parties. This is also known as the China-African Joint Arbitration Center, which I would also say that NCIA is also a part of. So NCIA is KJAP Nairobi. When it comes to West Africa, I will pretty much talk about Nigeria and Ghana. So Nigeria is the home of various arbitral institutions, including the Lagos Chamber of Commerce International Arbitration Center, also known as LASIAC, Lagos Regional Center in International Commercial Arbitration, the Maritime Arbitrators Association of Nigeria, and the Lagos Court of Arbitration. So it established in 1989, the LCI amended its rules, and in 2013, introduced its own form of emergency arbitrator procedure. When it comes to Ghana, there are two main arbitration bodies to note: the Ghana Arbitration Center and the Ghana Association of Chartered Mediators and Arbitrators. Both deal mainly with domestic arbitration, and the passing of the Alternative Dispute Resolution Act 2010 has provided both arbitration and mediation, and the court themselves are empowered to encourage the use of ADR. Just to note a particular peculiarity in Nigeria, most of these centers offer ad hoc arbitrations, and Jerry has given a detailed discussion on that in her previous discussion. When it comes to East Africa, there has been great progress that has taken place, particularly in Rwanda, Ethiopia, Tanzania, and Uganda. I'll give an example. Rwanda, we all know about Kigali. We have Kigali International Arbitration Center. They have administered disputes under its own rules and also under the UNCITRAL arbitration rules. They also provide for both domestic and international panel of arbitrators. Therefore, KIAC actively seeks to attract internationally renowned arbitrators. Kenya has also not been left behind. It's also made great strides in the area of practice, in this area of practice of arbitration, since its amendment of the Arbitration Act in 2009 and the promulgation of the Constitution of Kenya 2010, which promotes arbitration and other alternative dispute resolution mechanisms. This has, as Jerry will discuss further, with the recent jurisprudence and the developing guidelines by Kenya, Kenya has shown a great appetite to be at the forefront in the development of arbitration in Africa. Now, I will also not fail to talk about the Nairobi Center for International Arbitration within the region. It was formed by an act of parliament in 2013, and its rules of arbitration and mediation came into force in December 2015, and we've been in operation since 2017 to date. So when it comes to the regional status, or rather the status of institutional arbitration in Africa, we cannot go without talking about the SOAS Arbitration in Africa Survey 2020, which was conducted by Professor Emilia Onyema. And to note that the reporting period was between the year 2010 and 2019. It is noteworthy that this period is also at the time where most arbitral institutions in Sub-Saharan Africa were formed. The report has identified that there are 91 arbitral institutions within the region, actually within the whole continent in itself, and majority of them within the Sub-Saharan Africa region. So the exponential growth of these centers have been rampant from the early 2000s to date. The survey has also noted that some of these institutions do not administer, as I've just previously mentioned, Nigerian arbitral centers, but only provide facilities such as hearing room facilities, or only act as appointing authorities. One unique nature is majority of Sub-Saharan arbitral institutions provide capacity building and training in arbitration and other forms of ADR processes. Within the same breath, I will go ahead, cultivating, the differences between ad hoc and institutional arbitration. I'll go ahead and ask Njeri a question. Njeri, you may help us in answering the following. What is the future of ad hoc arbitrations in the region in the face of growing interest in institutional arbitration, particularly as there's a feeling that administered arbitrations may reduce to a minimum the possibility for corrupt practices to thrive? Thank you, Jerry.
I do not doubt that ad hoc arbitrations will continue to flourish. I think the confidential nature that they present or give parties who are in the middle of a dispute, their popularity will continue to grow. However, this concern of corruption, and I attended a conference just last week, ICC Kenya, where this was of great concern, and it seemed that the general consensus is that people may gradually be persuaded to accept institutional administration of arbitrations or institutional arbitrations simply because of that concern. So, as I said, I don't doubt, especially because think about all the contracts that are currently in existence that refer to having a third party default appointer, maybe like, as I said, the Law Society of Kenya, or of the Chartered Institute, or of the NCIA, which is growing in popularity, by the way, in terms of just appointing an arbitrator or a tribunal. I think it'll be a while before there's any change in that regard.
Well, thank you. Thanks, Nzeri.
So,
Thanks, Victoria.
we are not done yet.
Are you moving on to the next subject, or we're still on the?
Yeah, just about.
Right.
So, may I proceed?
Yes, sure. Please.
So, Victoria, having said that, what are the general and unique features expected by users of African arbitral institutions?
Thank you so much, Njeri, for that question. And it's good that you asked about general and unique features, because general features are those that would be expected of any arbitral institution, whether in Africa or globally. But unique features are those ones that would be specifically applicable within the region, particularly as regards to the African experience. So I'll go ahead and answer the general features. And this was discussed in detail with the SOAS report. So number one, a practitioner would expect that this institution will be in a convenient location and provide convenient facilities, has special hearing rooms and breakout facilities, has well-trained administrative staff, suitable and modern arbitration rules. They provide support in appointing of arbitrators, cost-effective, as Anna had discussed in detail, provide efficient case management systems, has access to state-of-the-art and efficient technology, for example, for recording purposes, translation, transcription, and video conferencing. The center or the institution is neutral and reputable, and has a panel of experienced arbitrators, and has provided a code of ethics for these arbitrators, and has digital and physical library, and provides online filing of documents. Now, when it comes to the unique facilities, which is expected by not only African arbitration practitioners, but practicing in these regions in this African region, then one of the most unique features is having multilingual staff and delivery of services, including arbitration rules, notes, and guidelines. Considering that we have, different users speak different languages within the region. We have speakers of French, Portuguese, English, Swahili, and those mother tongues that I would not even get into. I could say that Kenya has more than 40, tribes. So that's one of the considerations that you should keep in mind as an arbitral institution in Africa. You must have knowledge of African social cultural context, have adequate power supply, stable internet, particularly for virtual hearings, functioning and attractive website. And I think Anna actually discuss a little bit that there are few websites in place. So that's something that we should encourage the 91 arbitration institutions within the region. Independence from control by government, commercial and other organizational groups. Provision, I mean, the center should be, or the institution should be placed in a country where there's security of lives, property and documents. And then finally, arbitration rules should be in different languages and explanatory notes. So these are the general and unique features that would be expected in an arbitration institution within the region. Having that in mind, and noting the discussions about institutional arbitration as compared with ad hoc arbitration, probably I would love if Njeri would answer the following question. Taking into account the popularity of CIAB across the region, would it be advisable for the Institute to begin administering arbitration, or at the very least, take on the role of scrutiny of arbitral awards in the same fashion as the ICC and the NCIA?
Well, taking into account that long list that you've just brought to our attention, that institutional arbitration would require, it sounds like it would take a little while for that to happen, if indeed the Chartered Institute wished to proceed on that path. On the scrutiny of awards, I must say that this is one thing that has been considered, at least at the Kenya branch, but again, that requires quite some consideration. So it is quite an onerous task, being at the level where I do, on my part, do some scrutiny of awards for the ICC. So I'm not sure that on the Chartered Institute level, that would be the best way to go, at least for now. But it should be somebody should start thinking about it. On your part, Victoria, is there any feedback mechanism from users of services of these arbitral institutions? Are there any suggestions to realize their full potential?
Thank you so much. I would honestly say we do not have a lot of such, and I would just probe the source report for coming up with that mechanism that assisted the region in reporting on the progress of these institutions. Well, you may say that arbitral centers have, some arbitral institutions have been able to publish their caseload reports on the websites, but these are countable. And Anna also elaborated on that, like you cannot easily find these reports online. So for me, I would give congratulatory remarks to Emilia Onyema for coming up with this project. And she's been able to categorize, the respondents all over the world, from Africa, from the globe generally, have been able to give their response on how they rank top arbitration institutions in the region. So I would just give the following categories that have been made so far so good, but because we are referring to the SOAS report. So the SOAS report has identified top 5 arbitration centers, to include the Arbitration Foundation of Southern Africa, the Cairo Regional Center for International and Commercial Arbitration, Kigali International Arbitration in Rwanda, Court of Arbitration in Nigeria, and the Nairobi Center for International Arbitration. So the respondents chose these centers based on their experience, reputation, and location. This is not the only rank that has been given so far. So parties have also ranked the quality of the support or administrative services of African arbitral centers, with this as the top 5. AFSA again, Arbitration Foundation of Southern Africa, Cairo Regional Center for International Commercial Arbitration, Lagos Court of Arbitration, Nairobi Center for International Arbitration, and the Common Court of Justice and Arbitration of OHADA. So users of African arbitral centers have also indicated that they will recommend a couple of centers. Cairo Regional Center for International Arbitration again, Arbitration Foundation of Southern Africa, Kigali International Arbitration Center, Nairobi Center for International Arbitration, and the Common Court of Justice and Arbitration of OHADA. So I will not get in depth about the reporting itself, but just to show you, this is the limitation that we've had so far. We've not had such an elaborate report, and we are hoping that if centers, or particularly those administering arbitration within the region, can come together to give such outlines and encourage users or future users of arbitration to know that these centers do exist and that they can be used for the administration of arbitration disputes.
Well, thank you very much, Victoria, and to you, Jerry. This is truly fascinating stuff. I mean, we kicked off with looking at the legal infrastructure in the region, and the legal oversight, and then now we've delved into the legal infrastructure. And so next we are going to take a peek into the future and look at the recent developments concerning the AFCTA. We heard about the AFCTA in the beginning. I'll come back to you and Victoria, and Jerry later on towards the end, because I would like to hear if there are any landmark cases you want us to bear in mind. But before we do that, let's finish the tour. We'll listen to Anna talk about the FCTA, and then we'll move on to Bayomi for a close look at this fascinating project on the model BIT. So let's go to the future. Anna.
I believe it's Abayomi who's in charge of the covering it. I will comment. I'll be very happy to comment on that. Yeah.
Yes, please. I'll be happy to go first.
Absolutely.
Uche, just before delving into the AFCTA, 2 quick points regarding the last topic that Njeri and Victoria discussed. Just to note that I do recall that Corsica publishes its caseload annually every year, and it's one of those institutions that do publish its caseload. And the second thing is that we also have other useful surveys apart from Professor Emilio Yema's SOAS arbitration survey, which is an important one. The Africa Arbitration Academy survey on cost is one that also has dealt with some of the important points that Jerry and Victoria discussed. Now, moving swiftly to the AFCTA, let me just start with a background of the free trade area agreement. And the starting point for me is to know that the shift from OAU to African Union many years ago was meant to shift policies from forming mainly an integral front against colonization, in Africa, to maintaining peace and security through more development in the continent. And the attempt of African states started by establishing regional economic communities, which were called RECs. The African Union today recognizes 8 of those RECs. We have the COMESA, that's a common market for Eastern and Southern Africa. We have the Southern Africa Development Community, SADC. We have the Economic Community of West African States, ECOWAS. We have the East African Community. We have the Arab Maghreb Union, and other RECs that have been recognized by the African Union. Now, these RECs represent agreement among members daring to cooperate on political, socioeconomic, and peace and security objectives. And this was first implemented on the continental level by the adoption of the protocol to the treaty establishing the African Economic Community relating to free movement of persons and the single African air transport market. So the question is, if we have these RECs, if we have all these structures, why the AFCTA? Now, the AFCTA is aimed at bringing the continent under one free trade area in order to boost intra-African and socio-economic growth. It focuses on harmonizing the various trade regimes in the continent, which draws from the experiences of the RECs while building on their successes. And the vision for the AFCTA dates back to then I recall in 1980, the promulgation of the Lagos Plan of Action, which that plan highlighted different areas in which cooperation and integration will deliver sustainable development dividends and also set the stage for the conclusion of a treaty that will set out the roadmap for economic integration. There was an attempt to do so through the Pan-African Investment Code. Along the line, parties could not reach consensus on whether it should be binding or not. And so we have the AFCTA, which was established in 2018 by the African Continental Free Trade Agreement, which has 43 parties and another 11 signatories, making it the largest free trade area, FMNA, compared it to the World Trade Organization, WTO. Now, phase one of the AFCTA dealing mostly with the negotiation of trading goods and services, as well as the interstate dispute settlement was concluded in 2018, I think around March, and entered into force in May 2019. Now, trade under the AFCTA started last year, January 1st last year, 2021, and currently subject to negotiations. Phase two of the free trade area agreement concentrates on competition law, intellectual property, and investment. So I will be focusing more on the investment part, given that the investment protocol is currently being discussed and negotiated. Now, as part of the preliminary discussions, the ministers in charge of trade at the African Union have adopted the negotiating principles of the investment protocol, which was published, circulated last year. And this allows us to understand the main objectives of the protocol. And there are four main objectives, as I understand it. The first objective is Africanization. And I heard Anna mentioning that word Africanization, which I will use more frequently in the course of this discussion. Now, this emphasizes on the regulation of intra-African investment and requires investors to have substantial activity in Africa to benefit from the investment protocol. And the second objective refers to a systemic approach to investment, and one that prioritizes the regulation of investment protection, promotion, and facilitation, notably by encouraging states to promote Africa as a preferred destination for investment. The third objective relates to sustainability, and this seeks to incorporate sustainability criteria in the investment protocol as a way to build systemic integration between investment law and public international law. Now, the fourth objective is what we call codification. And I say this carefully because the last webinar that I joined and had some of the representatives of governments that are in the room discussing the investment protocol, they've said that the disposition in the room, amongst those that are discussing this, negotiating this investment protocol, is that they do not want to use the word harmonization because they do not believe that given the differences between the different RECs, the regional economic communities, and the different instruments that they have and the level of development in the countries under those RECs, that it will be easy to harmonize all the laws, harmonize the investment policy framework, but that they will prefer the use of the word codification. And this allows to codify Africa's best practices, taking into account all the models that have been developed in the continents, such as the SADC, we have the SADC model BIT, we have the finance protocol, and also the Pan-African Investment Code. Now, the investment protocol to the AFCTA, as I understand it, and I'm now sharing some of my personal views before I allow others to yield the floor to others to comment. For me, it will be an international investment agreement of a special kind. It will have unique features, which will be implemented in a manner that has not been, of course, seen before. The first aspect of this that is important to mention is that it will be a cooperation agreement, and it means that state parties will decide on the domestic enforcement framework because the protocol will not be self-executing. So it will retain national regulatory powers, and this being a prominent feature of the AFCTA in the first place. So the AFCTA protocol, for example, on the protocol on services, confirms the right of state parties to regulate in pursuit of national policy objectives and to introduce new regulations on the supply of services within their territories in order to meet the legitimate national policy objectives. So this essentially allows states to retain their power to regulate based on the national policy objectives. Under the AFCTA design, only the states, the AU, African Union member states that have ratified the AFCTA agreement and for whom it has entered into force will have rights and duties, and only they will be able to bring dispute under the dispute settlement protocol when provisions in the investment protocol are violated. So since most investments will come from private investors in third countries, there will have to be provisions on how individual states will protect the right of such investors under their national legal systems, aside what you have under the investment protocol. Another important indication of how the protocol will likely work as we are now looking into the future has to do with the fact that the RECs, the regional economic communities that are identified, will remain in existence because they constitute the building blocks of the AFCTA, and they'll continue to implement and advance their individual regional integration policies. Of course, that is the reason why the word harmonization they're trying to sidestep using that word and use the word codification. If you look at Article 8 of the AFCTA agreement, it's quite explicit that state parties that are members of other RECs, which have attained among themselves higher levels of elimination of custom duties and trade barriers, essentially to say that they will maintain the individuality and the independence of those RECs, even with the AFCTA agreements. One thing as a key takeaway from this session is that all the AFCTA state parties need resources and must attract foreign direct investment. And the investment protocol will not change the fact that individual governments will continue to compete for these foreign direct investment and will offer different kinds of investment incentives because the free trade agreement area is a member-driven arrangement and will not have supranational institutions. State parties will retain their national investment laws and institutions and will determine the rules on domestic incorporation of foreign firms, and investors. So it is likely that the definition of investor in the AFCTA will refer to enterprises governed by laws of individual state parties, as is typically done. So in concluding, the investment protocol is an opportunity to reduce the divergences and build upon the convergences, granting Africa what we see as an African voice on how to reform investment regime. Thank you.
Well, thank you, Abayomi. I was very tempted to invite one of our other speakers to jump in on that, but before we do, because we're kind of running behind now, perhaps I can invite you to just continue a little bit and tell us more about this fantastic project that you're working on, which kind of dovetails into what you've been talking about. And then after that, I'll invite our co-panelists to then comment on both areas that you just touched on. So if you can just go on for another 5 minutes.
Fantastic. Thanks so much. Yes, and it ties into each other, given that both deals with investment policy framework. And it has been truly fulfilling working, in relation to the African Arbitration Academy Model Bilateral Investment Treaty for African states, working with a diverse and talented group of practitioners from more than 10 countries to come up with what we see as a document or instrument, permit me to use the word, that will set the future when it comes to investment policy framework in Africa. So it is just a modest, the Africa Arbitration Academy Model BIT is a modest contribution to the ISTS discourse and promotes the codification of African state investment policy and laws. Now, the main objective of the Model BIT is to promote encourage and increase investment and enhance sustainable development in Africa. And you see that I've been using the word sustainability similar to what you find in the discussion to the investment protocol to the FCTA. Now, to support this objective, each article of the model BIT is accompanied by an explanatory note, which forms an integral part of the final document. And that explanatory note serves as an informative tool for negotiators in different African countries and even non-African states or officials when drafting and negotiating investment treaties, international investment agreements involving African states. The model BIT, just to note, is not intended to be, and it's not a legally binding document, but the model instrument, the adoption of which will depend largely on the negotiations, domestic context, and the adaptability by African states. And now, going to the meat of it, there are three important flavors of that model BIT as we see it. The first is Africanization, and I'm using that word again. The second is innovation and reforms, and the third is sustainability. Now, the Africanization flavor, what is that? The model BIT is substantially oriented towards an African approach, and it incorporates African principles such as the Ubuntu Zulu principle, referring to the importance of human dignity and equality. And by this, what we mean is that the model BIT considers the investors to be part of an ecosystem where they must be aware of the contextual situation of their investment. The model BIT also incorporates protection of traditional knowledge, innovations, and practices of indigenous African communities, and encourages the equitable sharing of the benefits arising from the utilization of such knowledge. Prior to now, apart from what you find some few provisions in the Pan-African Investment Code, you will typically not find in any bilateral investment treaty in Africa provisions relating to protection of traditional knowledge and traditional cultural expression. And it goes further. The model BIT also recognizes the right of indigenous communities to file amicus curiae briefs. We've seen in recent time in investment arbitration that some tribunals do allow such briefs to be filed, but this particularly relates to those communities filing amicus curiae briefs in relation to dispute relating to, or that may impact traditional knowledge and traditional cultural expressions or genetic resources that form the core subject matter of the dispute before the tribunal. Now moving to the sustainability flavor, the model BIT prioritizes provisions on sustainability and acknowledges the importance of sustainable investment in Africa. The last flavor is what we refer to as innovation and reform. Most of the substantive provisions are carefully and innovatively drafted and reform-oriented. For instance, the model BIT contains modern provisions on dispute prevention, the right to regulate by state, the balance of the rights and obligations of states and investors. It incorporates useful provisions on third-party funding. We see that the Ancestral Working Group 3 has now proposed the provisions relating to regulation of third-party funding in investment arbitration, protection of state actions during pandemics, and prevention of corruption, money laundering, injury, and Victoria referred to corruption. So the model BIT has provisions relating to prevention of corruption, money laundering, and terrorism financing in relation to investment in Africa. And I'll just pick one of these major points, and then use it to exemplify some of why the model BIT is very important. For example, on third-party funding, the model BIT mandates what you see as systematic disclosure of the existence of funding and the identity of funders. And this is similar to the approach taken by ICSID in the recently revised ICSID rules. It imposed an obligation on the funded party to disclose if it has completed the third-party funding arrangement and the name of the funder at the earliest possible opportunity, either at the registration or completion of the funding arrangement, even after the case has begun. It further also provides for is a continuing obligation on parties to disclose any changes that is made to the funding arrangements that may impact on the case or issues relating to security for cost. And on security for cost, the issue has always been whether the tribunal should award security for costs when the claimant is funded by a third party. And the basis for concern is that recourse to third-party funding indicates at minimum a lack of ready cash to fund the arbitration. So a funded party may be unable to comply with any costs award rendered against it, particularly where such party is impecunious. So the model BIT provides that the arbitral tribunal shall consider all evidence adduced in relation to the circumstances of the case, and third-party funding arrangement being one of those circumstances that can be considered by the tribunal. But the conclusion of or the existence of third-party funding is not of itself sufficient to justify an order for security for cost. So to sum it up, in the interest of time, I would say that the model BIT provides what we see as a unique approach to balancing the relationship between investment promotion and sustainable development. It has been developed as a comprehensive document comprised of uniform text which African states may adopt as a basis for developing their specific model investment treaties. Right now, we are in the stakeholder engagement stage. We are discussing with different African governments, taking them through the useful provisions in the model BIT so that they can get familiar with it and begin to use it for future negotiations of their BITs and international investment agreements. And to round up on the final note, we are hopeful that the model BIT will help to promote, encourage and increase investment in Africa, which is particularly important because national BITs can create a fragmentation that could frustrate national integration. So we were looking at a stage where Africa will have to speak with a single voice, and I think the model BIT provides that opportunity.
Thank you so much. That's a lot of material there. I'm sure our co-panelists are waiting to jump in. We have 5 minutes. We have 5 minutes to go. So maybe I'll start with Anna, because you may have one or two things to say about the model BIT and the AFCTA. But we can keep it brief. I should have also mentioned that members of the audience can send in questions using the chat function, and we'll see what we can take. So, Hannah?
Yeah, sure. Thank you. Thank you, Uche. Thank you, Abayomi, for such a fascinating presentation, and also for developing such an amazing and important project. And congratulations to Efemina too on his participation in the preparation of the model BIT. Well, I'd love to discuss many aspects that were included in the model BIT. I'll try to focus on 3 aspects. I don't know if Uche finds it adequate, but I'll try to be brief. But first, focusing on the AFCFTA, I think that we could just, after hearing Abayomi, I think we could reflect on the ways in which AFCFTA could support resilient and sustainable investments in the next decades, which will probably be marked by increasing environmental and climate pressures. We all know that developing countries are the most vulnerable to the effects of climate change, and are also the ones that need investment and industrial development the most. So in a context in which climate justice is growing increasingly topical, I wonder if the AFCFTA is could be identified as a way for African states to develop their self-resilience and sustainability together. So we could also wonder the ways in which the investment protocol, as it is still being negotiated, as well as the Africa Arbitration Academy model BIT, could also embed environmental and climate considerations within the AFCFTA, because that has been a critique so far. The second thing, moving to the model BIT, and also looking at the ways in which the model BIT's reform and sustainability objectives that Abayomi explained could be achieved. I found particularly interesting that the word shall was introduced in most, if not all, provisions of the model BIT. The new generation BITs have shaped provisions such as corporate social responsibility as best efforts clauses, using language such as encourage to, which is the case of the Pan-African Investment Code, Articles 29.2 and 30.1, as well as will endeavor to. And of course, I understand that we are looking at a model BIT, which hasn't been subject to negotiation by state parties yet, to my knowledge. But as it is, the model seems to have been designed to have teeth, which is probably desirable considering the discussions Abayomi raised about the AFCFTA. And as it is, and just to play a bit the devil's advocate for the purposes of the discussion, I wonder whether the BAT will not actually encourage parties to prevent disputes through the Joint Treaty Management Committee, or in the alternative to resort to international commercial arbitration, as the BAT might be too burdensome to investors. And a third point, very quickly, looking at the aspect that will probably draw the attention of arbitration practitioners the most, is the Joint Treaty Management Committee, which I also found particularly interesting. And it resembles joint committees that have been implemented in other recent BATs, such as the Brazil-India BAT. These model BAT committee is interesting from my perspective for two reasons. One is empirical, the other is legal. First, most of the times, I think that preventing disputes is probably in the interest of all parties involved in complex long-term investments, especially due to costs and the negative impact disputes have in the preservation of the investor-state commercial relationship, especially if we are speaking about state-backed foreign investments, such as Chinese investments or export credit agencies. These may be unfortunate news for arbitration practitioners, but that's what empirical studies show. And from a legal perspective, the committee is also interesting because it reaffirms the state parties' control over the treaty through joint treaty interpretation, as has been suggested by Tsanakopoulos and Mitsumaki, leaving the investor out of the scene. So this means that bringing claims to the committee will therefore require political muscle from investors, as they will need to articulate the move within their home countries and convince their state of nationality to support them in pursuing a particular interpretation of the treaty. And lastly, one aspect that remains unclear is whether the committee's settlement report is actually binding. And I'm looking forward to see how that is going to play out, and also whether the committee's interpretation would be applicable to ongoing cases or only to future cases, which is a matter of timing. Thank you so much. Thank you, Abayomi.
Well, thank you, Anna. We started off this session by pointing to the size of the both in terms of people and geographical size and complexity of the legal systems and so on. And we could continue the whole day without even scratching the surface, but the wonderful panelists have managed to really give us a lot to think about. I can't thank you enough. This is truly fascinating stuff. I believe we're going to be moved to breakout rooms, and there will be opportunity to raise questions with the different speakers. So we really have just hit the time mark, and so we'll be going into the breakout rooms. Thank you so much. Thank you, Anna and Jerry, Victoria, FMNA, and Bayomi. This has been really fascinating. Jose Antonio.
Thank you very much, Uche, and let me say thank you to each one of you. I'm saying your names in the order that you appear in my camera. So Jerry Kariuki and Dr. Abayomi, Victoria, Ana Carolina, and FMNA. Thank you very much, because this was truly a comprehensive look into what I believe is an incredible, difficult task. We tried to encapsulate it by saying Sub-Saharan Africa, but as some of you pointed out, it is incredibly diverse, difficult, 48 jurisdictions, several systems of law, several languages, and I think that you have managed to give a true sense of the incredible legal, cultural diversity that exists in the region, and I would only like to emphasize how you were able to go from present and include some of the past, and also end up with a note of the future. With respect to the AFCFTA, I would only like to emphasize that the African continent, and specifically Sub-Saharan Africa, has already been a successful proponent of investment treaties that are not only model BITs, but are actual in effect treaties, such as the Morocco-Nigeria bilateral investment treaty, which is one of the few treaties that includes actual obligations for investors, not in the preamble, not in hortatory language, but in operative provisions that bind the investor to respect social corporate responsibility standards and others, which is a reality, and some commentators and arbitration practitioners, including myself, are also looking into what additional novelties the African continent may put on the table for the world to sort of follow through, to make more balanced BITs that would on the one hand still protect investors, but also would create obligations as should be for investors, minimum standard in obligations. And with that, I would like to welcome everyone and go on to the breakout rooms. Thank you, Uche, for the masterful preparation of this panel. And the breakout rooms is simply a safe space which has no recording for people to relax, ask whatever they want, not only about BITs or about investor arbitration, but it's a set of rooms with no agenda for people to know the stars who are you. Okay, so let's move. Perhaps we'll have at the most 2 breakout rooms or 3 breakout rooms at the most. Thank you.